Good evening, everybody. This is the Carver Zoning Board of Appeals meeting for August 6th, 2025. We are in room 1 in the Carver Town Hall, and we are happy, as always, to have Area 58 recording us. Now, it is our custom to address minutes from our previous meeting when we commence. So I want to ask everybody if they've had an opportunity to review the draft minutes, which were circulated in advance of this evening. These are the minutes that were generated as a result of the meeting on what date?
July 22.
23rd.
July 23rd. Thank you. Has everyone had a chance to review those
Yes.
minutes?
Yes.
Anyone want to make any changes, amendments, or modifications?
No.
Do I hear a motion?
Motion to accept the minutes as presented?
Second?
Second?
All in favor?
Aye.
So those are accepted as written. Thank you, everybody. And now we go to our business for this evening, case business. And I would ask Member Poirier to read the notice, the public hearing notice, into the record. Thank you.
Public hearing continued, case 29-9-B1-R, petitioner David M. Baston requesting a special permit pursuant to sections 2260 to 2263, 5221, and/or 5300 to 5330 of the Carver zoning bylaw for property located at 15 Pleasant Street in Carver, Assessors Map 29, Lot 9-B1-R, so as to construct an attached 1,448 square foot accessory apartment. 800 square feet is allowed as of right in the residential agricultural district.
Thank you. Now, this case appears before us for the third time this evening. On the first meeting that this board conducted concerning this case, which was on August 6th, I think, 2025, is that right? No, it was on July 23rd, 2025.
It goes back further than that.
Does it?
Yes.
Yeah.
Okay, well, it is the third time that this case has appeared in front of us. The first time, we spent a considerable period discussing and eventually directing the petitioner to the planning board in view of the fact that it was the consensus of this board that what this petitioner was asking for was outside the jurisdiction of the Zoning Board of Appeals. Jurisdiction is just a fancy legal term that means the power to hear a case or the authority to hear a case. Then, at our last meeting, which was on, what's that date again?
July 23rd.
Thank you, July 23rd. This case reappeared, I think somewhat to the surprise of all of us. And there was considerable attention paid to this case at that time. And there was considerable testimony taken from the petitioner and the petitioner's supporter, the building commissioner at that time. To recapitulate, the building commissioner, Mr. Palmer, appeared on behalf of and in support of the petitioner's appeal from his own letter of denial dated November 2, 2024. And that letter of denial had to do with the petitioner asking for an oversized accessory dwelling unit, which would be, based on the record, the second within this property. Everybody recall that? Yep. Now, Mr. Palmer gave his opinion that this accessory dwelling unit which I will refer to hereinafter as an ADU, currently located in the property, was merely extra or incidental living space and was not actually an ADU. Accordingly, again, his opinion was that the petitioner's present request for a purported second ADU for his in-laws would really be a first ADU. Everybody remember that? Mm-hmm. He also gave his opinion that the then building commissioner and the ZBA made an error when the former required the petitioner to come before the board in 2002 for a special permit, which the board granted on November 20, 2002. And we reviewed that decision, didn't we, everybody?
Yep.
Yep.
I don't think there's any doubt but that what was requested that time was an ADU. And the written decision at that time reflects this. Would everybody agree with that?
Yep.
Yes?
Yes.
Okay. Stop me at any time if there's a confusion or disagreement. Now, Mr. Palmer drafted a letter dated May 27, 2025, expressing his judgment after inspection of the subject property on May 6, 2025, that what was being requested by the petitioner would make his property a two-family home. There was no mention in that letter that the current ADU that's in there was merely extra or additional living space. And I remember bringing that up myself 2 weeks ago when we were here. We reviewed the board file from 2002. It was discovered that the application of the petitioner was clearly for an ADU for his in-laws. And the board decision was also reviewed and states clearly that the relief granted was for an ADU at that time. Everybody remember that?
Yes.
Yes. Now, we had extensive discussion up here whether the decision of 2002 could be perhaps amended if the members believe this to be appropriate. Some concern was expressed that if this were to occur, it would establish a precedent for others who wish to come back before the board to change previous decisions. Mr. Palmer also expressed his opinion that the proposal of the petitioner, if it were counted as a second ADU, that the petitioner would be put to great expense due to state and building code fire suppression requirements. We asked him for an estimate as to these costs. He declined to estimate other than to say that he knew it would be expensive, and I see the assistant chief here tonight who has appeared at our request. Everybody remember that we asked that at the last meeting? So we thank him for being here this evening, and we will hear from him shortly. There was also discussion at our last meeting, and this has come up periodically over time, that or whether a kitchen is required to be considered an ADU. It was observed that the board had, for a long period of time, many, many years, had always considered this to be the case. So at the request of Vice Chair Mello, an opinion from legal counsel was sought to assist the board in assessing its options at this time. And as I said, it was also suggested that a representative of the Carver Fire Department be invited to the meeting this evening to speak about fire suppression requirements and costs. I think that's a pretty good summary of where we left this. So let's talk about the legal opinion that was received by this board, initially at the request of Ms. Mello. Has everybody had an opportunity to review that legal opinion?
Yes.
Now, this legal opinion from counsel is pretty straightforward. I don't read this as being waffling on the issues at all. She says that reclassifying the existing ADU as additional living space will not solve the issue here, as the kitchen will still exist. You've got the kitchen in the main part of the house. You have a second kitchen for the ADU that this board granted in 2002, and now you propose yet another ADU, which will also have a kitchen. There was some discussion at our last meeting about whether a kitchen appears in the definition of ADU. It does appear in our bylaws. The ADU definition speaks to dwelling units. And dwelling unit is defined in the zoning bylaw as follows. It shall mean a building or part of a building occupied or suitable for occupancy as a residence and arranged for the use of one or more individuals living as a single housekeeping unit with its own cooking, living, sanitary, and sleeping facilities. Legal counsel goes on further to state that in her opinion, the 2002 special permit that was granted for that first ADU at the property is final and cannot be reclassified. She says there's no provision in the Zoning Act, that's state law, Chapter 40A, to amend or modify a special permit. So a new special permit would have to be granted in this instance, where the petitioner is seeking what I think everybody believed at the time of his application was a second ADU at the property. Now, let me stop here and ask any of the board members whether they have any comments or questions so far about the history of this case as I recited it, or the opinion offered by town council at the request of Vice Chair Mello.
The only thing I want to bring up, I did go to town hall and see if there was a definition of dwelling unit back in 2002. And they could not find the zoning bylaws for 2002. But they did find a copy of the zoning bylaws for 2003. And dwelling unit is listed in the 2003 zoning bylaws, and it is the exact same definition that was just read. So for 20-plus years, we've used this definition.
Now, I will add one other thing that's developed recently, and that is this town had a town meeting in April, I think it was. Is that right, Ms. Dahl?
I think so.
And there was discussion at town meeting about amending the bylaw for ADUs, which passed. Part of the bylaw, the new one, that was passed this year at town meeting provides a definition for accessory apartments, also known as ADUs. And I'm going to read this into the record, because this is the definition under which this petitioner must understand that he operates. Quoting, "A self-contained housing unit consisting of a complete separate housekeeping unit containing both kitchen and bath incorporated within a single-family dwelling or existing detached structure that is clearly a subordinate part of the dwelling, which complies with each of the use and dimensional regulations stated in the bylaws and also under Massachusetts General Law, Chapter 40A." So, again, it seems pretty clear based upon the state of the bylaws in 2002, the decision that this board rendered in 2002, favorable to this petition, legal counsel's more recent opinion, and the definition of ADU that is in our new bylaws as passed by town meeting. And I will say, parenthetically, that the Attorney General now has approved this bylaw. Whenever there is a bylaw change, it goes over to the Attorney General. The Attorney General has to review it. There are a couple of things that the Attorney General felt were not appropriate, a couple of words that are not pertinent to your situation. But that's where we are with this. It's a complete separate housekeeping unit containing both kitchen and bath. Now, the petitioner has testified that this so-called second ADU that brings him here before us again tonight has a kitchen, or he intends to put a kitchen in there, and a bathroom, and separate living space for his in-laws, who, by all accounts, seem like very nice people, as does the petitioner. But we are constrained by the law. You've heard me say this many times. No matter how compelling a situation may be, and how much we may like a particular petitioner. Let me stop here again and ask any of the board members if they have anything further that they'd like to add or have clarified. I'll poll the board. Mr. Barrington.
No, I think everything was spelt out very clearly.
Mr. Poirier.
Well, the only thing that I kind of found interesting in the decision that you read is one of the last lines. It says, however, if the kitchen is removed from the existing ADU, it is likely no zoning relief is needed.
Right.
So,
And we'll get to what relief may or may not be needed. I just want to get this history of the case and legal opinion as requested by the vice chair into the record. So I ask Ms. Dahl if she has anything further that she'd like to say or have clarified at this time.
No.
And Ms. Mello.
I just wonder if there's anything else in the Attorney General's information that was sent out that would apply to this case.
Well, I have the decision or a letter from the Attorney General, which I'm happy to pass on. She doesn't speak exclusively about ADUs, because there are a number of other things that she addressed, like bedroom limitations and...
Special permits. I thought in
Yeah.
there was a kind of a...
parking space requirements.
You can't require parking.
Right. So, dimensional requirements. So there's nothing really
Could I-
that addresses, sure.
Thank you.
There's nothing that really addresses the issue about having a kitchen and sanitary facilities under the same roof, other than what I read. Now, there is one other thing before I
Yep.
defer to Ms.
Yep.
Mello. When town meeting passed its new bylaw on ADUs. There was a recognition at the time that under Massachusetts General Laws, Chapter 40A, Section 3, more than one accessory dwelling unit within a home or house lot shall require a special permit from the planning board. That's pursuant to Section 9 of Chapter 40A. And I want to say that again. Pursuant to Chapter 48, Section 3, more than one accessory dwelling unit within a home or house lot shall require a special permit from the planning board. And they refer over to Chapter 48, Section 9 as well for the authority for that statement. I will say again that when this board heard this case initially, its direction to you, Mr. Baston, was to appear in front of the planning board. Ms. Mello.
And I'm no lawyer.
Yeah. It's only with, the only section that the Attorney General's office bounced back is the section in heavy bold.
Single
referring to
family.
Single family,
Okay.
single family.
All right.
It's inapplicable to the legal issue that we're addressing now.
Okay. Thank you.
Yep. Board members to my left, any questions or comments so far?
Yep.
And to my right? Okay. Now, aside from the fact that it has been suggested that what you have currently is not an ADU, but rather just additional living space, it seems to me that that is an attempt to do an end run around the decision this board generated in 2002 based upon your own filing and request, and also based upon your request in the current case, where you say you want to have an ADU that's oversized, which is fine. But it appears as if, by all accounts, the official paperwork in the file refers to 2 ADUs. And town council cautions us against trying to reclassify or reverse previous decisions. She says we do not have the legal basis to do that. And so long as you've got a kitchen on one side and plan to put a kitchen on the other, this case appears, based upon state law, to need to go before the planning board, as we suggested initially. Now, I understand completely that if this is characterized as a second ADU, which by all accounts, to me anyway, it seems to be, then there are issues relating to cost, because you're now in a situation where you're going to have to be in compliance with state law and codes as to fire suppression. And this might prevent you from doing what you want to do if it's going to be cost prohibitive. So I think at this juncture, I'd like to hear from the Assistant Chief, who will be able to speak more definitively about this issue. So if you could identify yourself, we'd be grateful.
Test 1, 2, check, check. Good evening, Mr. Chairman, ladies and gentlemen of the board. My name is Jesse Boyle, and I am the Assistant Deputy Chief of the Carver Fire Department, and my job description entails code enforcement, fire prevention, public education, which I think I'll have the opportunity to do all three of here this evening. Great. And it's an interesting case. I've been following it along. I've had conversations with Mr. Palmer. I have not had the opportunity to have a discussion with the applicant as of yet.
He's a very nice man.
Hi, I'm Jesse.
He's sitting behind you.
And I'm not a lawyer, but I play one in ZBA meetings. And my interpretation of the definition of jurisdiction is stay in your lane. I think that's Latin. And my lane is Massachusetts General Laws 148, which are the fire prevention regulations, and the Massachusetts Fire Code. And I get to dip my toes a little bit into the Massachusetts Building Code, but it's primarily the building official's jurisdiction. Allow me to indulge in some semantics. In-law, duplex, triplex, townhouse, apartment, condominium, lodging house, boarding house, fraternity house, hotels, motels, ADU, multiple dwelling units, and now with Airbnb, short-term rentals. Those are legal definitions. However, you will not find most of those mentioned in the fire code. The fire code mentions our word of the day, which is dwelling unit. And I brought with me the definition of the dwelling unit as per the Massachusetts Fire Code and with the Massachusetts Building Code. And it's nearly word for word what I've heard here tonight, except for, interestingly, one key difference. And in our code that we're responsible for, the word independent stands out, as well as the same word in the Building Code. I'll read it for you just for posterity. A dwelling unit as defined in Mass 527 CMR 1, 2021 edition, is one or more rooms arranged for complete independent housekeeping purposes with space for eating, living, and sleeping, facilities for cooking, and provisions for sanitation. And that's it. It does start to get into the discussion of one and two family dwellings and the extent of family members, but the reason that we stop defining it past two family members is once we exceed two and get into the territory of three dwellings within a structure, that's when the requirement for sprinklering comes into place. And again, no discussion on ADUs or triplexes or duplexes or any of those what are sometimes real estate terms or zoning terms. The fire code doesn't speak in that language. We have to, obviously, before anybody can build anything, it has to get through local planning, local zoning. Once that's all approved, then we take the fire code and give our stamp of approval. Any questions on that information so far?
Nothing. Nope.
Okay. Now, the fire department is the authority having jurisdiction of the AHJ for the fire code. And again, we have some overlapping responsibilities within the building code between myself and the building official. And it's the same way in every town throughout the Commonwealth. And most towns, the building official and fire department work very well together, and I can certainly say with pride that we do here in Carver as well. I have not been to 15 Pleasant Street. From what I understand, looking at the assessor's card and listening to this meeting, I think there's certainly some room for debate as to the status of whether it's one or two dwelling units. With looking at the term independent in our code definition, I would lean on the side of it not being a separate dwelling unit, with there not being a separate entrance. There's not a separate electric utility. It's essentially congruent with the existing facility. However, we tend to err on the side of safety, and the code requires us to do that. Despite how black and white the codes are, there's a lot of, no pun intended, Mr. Chairman, there's a lot of gray area in between those black and white sections. And it's up to the code official with our experience and education to make determinations for what's best for both cost as well as safety. The code also says, in the event that it's unclear what to do, you err on the side of the more intense part of the code, which would be to sprinkler the unit. And as far as the costs are constantly changing. Well, they're constantly increasing. I should say that they seldom go down. The industry standard for adding sprinklers to this type of dwelling, and there are three essential types of sprinkler systems, and this type of dwelling would require the least invasive, which is essentially designed for occupant egress only, and not to protect the structure or keep the structure in one piece as a full-size sprinkler system would be. Essentially, The industry standard is $1 to $3 per square foot for new construction, and $2 to $7 per square foot for existing construction. As Mr. Palmer has described, it's much more invasive unless people want pipes running over their walls, and most don't. I believe those numbers are a little bit outdated. I think you could probably put 30 to 40% to increase on top of that. Additionally, as we all know, Carver does not have a municipal water supply. And there are provisions within the Mass Fire Code that require a water supply to be added. And we have probably close to 200 existing sprinkler systems in our town that do not tie into a municipal water supply. So we have the precedents there, and we wouldn't have a problem requiring that. But that comes at an additional cost for the project owner. They would have to install a tank and a pump to provide the amount of water to essentially flow water for only 10 minutes. It's not an infinite amount of water, it's 10 minutes, but that's enough for people to escape. Again, not a contractor. These aren't quotes, but these are just general numbers that have been around for a while. Is there anything else I could answer of the board, or any clarification on any of my statements?
Anything so far, ladies and gentlemen?
Nope.
I have a question.
Yes.
If the ADU unit is not attached to the two-family structure, how is that handled?
Then there would be no requirement to sprinkler it. Yeah, we're talking, and as far as the world of ADUs, you have inclusive as if it was in, let's say, a basement or a third floor. And then you have an addition, which would be an attached unit, and then the detached. So the detached would not require a sprinkler system. It would require, obviously, to adhere with our zoning requirements as far as setbacks, and we would look for distance in between the existing structure and the new structure. You know, they couldn't be an inch apart, for example. I think we would look for at least 10 feet, and that's something that would be determined through the building code.
Could they be attached by like a porch or total, or must they be totally separate?
That's an interesting question. So in Carver, we have our own bylaws that require sprinkler systems for 2 or more units in any subdivisions in town. So we have subdivisions, we have condominium complexes, we have townhouse complexes with only 2 units that are sprinkled. We've required them to be sprinkled. Now, townhouses are required to be connected. So we've, special permits have been issued by our planning board. This is a roundabout answer to your question, by the
Yep,
way.
that's
So allow me to digress. And those plans were such that the buildings were not connected. Well, you're not allowed to build a certain amount of detached units within a certain parcel. You can build townhouses if they're connected. Those were allowed by building officials in the past, prior to Mr. Palmer, that allowed them to be attached via a porch or an overhang. So those were still attached, and they classified as now being a townhouse. So I would say, just briefly on your question, if this detached unit was still connected via a porch or some sort of structure, it would be attached, and then therefore would trigger the requirement for sprinklers
Okay.
because it's now 3 attached units.
Okay.
And I might add, in support of what you just said, that the town meeting in April, when it passed its new ADU bylaw, had a section that I will quote from: "A self-contained housing unit consisting of a complete separate housekeeping unit containing both kitchen and bath incorporated within a dwelling or existing detached structure." So I would concur with the observation that you just made. There was some discussion, just so that you know, about whether this petitioner's application be helped if the so-called second ADU were detached. It does not appear to be an option at this point based upon the Carver bylaw. And again, I would emphasize to everybody listening that pursuant to state law, more than one accessory dwelling unit within a home or house lot shall require a special permit from the planning board. We don't have the authority, and it's way above our pay grade, to argue about the fairness or justice or efficacy of state law. Mr. Boyle. What else?
One of the more interesting gray areas of this, in looking at this keyword of independent that's in our code, is there's no further definition of that. Now, if I were to consider through logic of what independent means, it would start speaking of fire separations. So if there's a fire in one unit, the fire separations keep the fire on the other side. And again, from the description of what I've heard, that doesn't exist with this existing expanded living area. There's no fire separation. Now, I can't speak to what the code was in 2003, but I do know that the codes evolve. And the codes evolve typically because of a loss of life. That's how our code works. That's how the building code works. And the fact that there's no fire separations, there's no separate entrances, would lead me to believe that it is not a second unit as it stands. Again, I haven't been there. I haven't seen it. I've looked at the assessor's card and the aerial mapping software that the town provides the fire department, and I've listened to Mr. Palmer's testimony.
Do you have anything further for us?
I don't.
I want to thank you for
Thank you, folks.
taking time out of your schedule, especially this evening. Do any of you up here have any questions or issues that you'd like to explore with this individual?
No, I think he answered the questions that I had.
Okay.
All right, I thank you for involving the fire department in this process.
You bet.
Thank you.
Thank you, Mr.
Thank you.
Boyle. You show it to Jim?
I did.
Thank you. Now, we have also received a lengthy email this afternoon. I think I got it about 2 o'clock, which I passed on to everybody. Did everybody see that?
Yes.
This is authored by a Robert Belbin, who asked me to read this into the record. I'm not going to read it into the record. It's lengthy. And it talks about his experience before this board some years ago. And we're not going to relitigate that case. However, it's difficult to understand, but it seems as if he's suggesting that what we thought was being built in 2002, that ADU, is not really an ADU because it fails to meet building code or health and safety laws. That argument for me has no force whatsoever. The reason being is because what was pitched to us at that time by this petitioner was an ADU. The paperwork clearly reflects that, as I've said already. And this board granted that ADU. Now, the fact that that ADU, as constructed by this petitioner, may be deficient in some respects based upon the building code or health and safety laws does not change its classification, in my judgment. This is an ADU. It's got a kitchen, it's got sanitary facilities, separate living and sleeping quarters. It satisfies the definition under the Carver zoning bylaws. So the fact that there are some code deficiencies in this case does not change what this thing is, in my opinion. So I ask the board to make any comments it wishes to make on this particular argument. I think this is what this gentleman was trying to say in his email. And by the way, I have placed a copy of this email in the board file for anybody who would like to review it later on and down the road. So Ms. Dahl, do you have anything further you want to add?
No.
One thing I'd like to say that as a board, we have voted on and taken a policy that communication has to arrive to the board 48 hours in advance of our meeting.
That's true.
Not that this should not go into the record, but I do want to emphasize that it is difficult for us to get information 3 hours before we sit down and meet.
Agreed.
Mr. Poirier, anything further about the merits of the argument as presented by the author of this email?
Well, it also seems to be in keeping with what we heard from town council.
And Mr. Barrington?
Agreed.
And I will say also that I recall, and please, folks, correct me if I'm wrong, that Mr. Belbin attended the first of these 3 meetings that this board has had on this particular case. Am I right? Is my memory correct in this regard? And he spoke at that time in favor of the petitioner's request for what he characterized by way of his own application as a second ADU. And the building commissioner denied it based on that characterization. So I think that the argument that, or the arguments that have been made in this case have been fully developed and have been chewed on repeatedly by this board. We have had 3 meetings. We have had 2 legal opinions. We've had testimony from our building commissioner. We've had testimony from Deputy Chief Boyle. I think this board has done its due diligence. I think it's pretty clear that what we suggested that you should do the first time around is still, in my opinion, what you should be doing this 3rd time around, which is to go before the planning board. It's there for you in black and white. Mr. Barrington.
Mr. Belbin was here, and that was on March 26th meeting. And he did present his argument at that time. So I was just going back to, so we were as accurate as we can be with the information presented.
Anything that you'd like to add with regard to the merits of this petition?
No?
Mr. Poirier.
Well, I'm just wondering if, in light of everything that's gone on, has the petitioner thought any differently about what the project might look like that would help to get him something on what he's interested in doing?
That's a great question, Mr. Baston.
Is it all right if I bring these up and use these?
Is this new stuff?
So it's stuff I think is relevant. But, and let me address the board with I have some thoughts on all of this as well.
Thank you.
Thanks very much.
Thank you.
I know you're well aware of this court ruling with regard to number of kitchens in a house. I've heard a lot about how the number of kitchens or the kitchen sort of defines the unit. But that may not be completely true, regardless of anything else. And I take a little bit of offense to the insinuation that I'm trying to do an end around here, because that is not at all what I'm trying to do. The first meeting that we had actually was for the overage square footage, as you indicated. And the issue then was that during the course of that meeting, it was brought to our attention that Carver had a bylaw at the time that you could not have more than 1 ADU on a residence. So you sought legal counsel to see if that could be, how that could be addressed or sort of taken care of, or whether it was actually, when we came back a month later, town meeting had occurred and it had been voted that 2 ADU units could be, could exist on 1 residential unit. So at your recommendation, I withdrew my application from here and I went to the planning board. I went to the director of the planning board, whoever it was, and I spoke with him directly. And his response was frankly, was a little bit direct. And he said, I can't grant you a permit for second ADU because I don't know if you have a first one. And didn't bother to give me any other information. At that time, it was recommended that perhaps a site visit from the building commissioner would help to shed some light on whether I actually had an ADU or not. And if I didn't, then I could have simply apply as I had applied and come back to you to see if the overage square footage would be approved. And so that's what I did. Each step that I've taken, I have followed recommendation from town employees, from boards, from people. I have not tried to do anything around anything. That's not who I am. And in 2003, I came before the board and I applied for a special permit for an apartment. I wanted an apartment. I wanted it to be an apartment. I wanted it to be separate. I wanted to be independent. My mother-in-law at the time was going to be living there. I knew the only way I could live with her is I needed to see her as little as possible, right? So we needed to have privacy between us. So that's what I applied for, and that's what was approved. That's what I expected to build. I hired licensed contractors who built it, who applied, who submitted, and Rod, this is maybe where you can help me to make sure I understand the process, because I'm trying to follow this through. So in order to build this ADU on my house, a building plan had to be submitted to the building commissioner and approved by the building commissioner, is that correct, at the time? Because it had to be up to code for fire safety, for all those other things.
Let's spin.
Please, hold on, please,
Go ahead.
if I could. That plan was approved as it was submitted to the town. It was approved. Then along the way, there are periods where inspectors come out and the construction, whether it's electrical, plumbing, or building, has to pass inspection at certain points. Is that right? That's right. That's right. In order to gain occupancy to that addition, all of those inspections have to pass. Is that correct? That's correct. So the unit has to be up to code in order to occupy it. If my unit as an apartment, as an ADU, was not up to code along the way, why did it pass every single inspection? Why was I allowed to occupy it?
I can't answer that question for you.
So my point...
What I can say
Yeah.
is that what you asked for and what you were granted
Right,
under the
correct.
law was an ADU.
So I agree with you 100%.
Whether this should have or should not have passed inspections, I'm not going to characterize why that was, whether people dropped the ball.
Right.
I can't tell you that.
So
But
some-
what I can tell you is, you were granted an ADU. We
Correct.
saw the plans.
Correct. That's what I wanted. I wanted an ADU, correct? That's exactly what I wanted. That's what I applied for, that's what I was granted, that's what I wanted. But in the course of construction, it did not come out as an ADU because it did not meet code. Even the deputy fire chief here says that because there is no fire retardant wall between them, technically there's not independence, right? So I have this apartment that I thought I built that maybe someday I would like to rent out. I can't rent it now. It's a loss of income for me, potentially. I've been paying taxes on a two-family home for 22 years that may technically not be a two-family home, right? Based on some of what we see here. I'm not here asking for anything back. I'm not even here saying that you did anything wrong. You issued the permit that I wanted. I'm saying that the town didn't follow through to make sure it was built for the permit that I was issued. They passed it through anyway. So now I'm here in
Mr.
front of you
Bassett, let me ask you this.
sort of
Do you
stuck.
not take responsibility for what was built in there?
So I am not a builder. I'm not a contractor. I don't
But
know
you're
town
aware
code.
there are codes.
So of course I'm aware there are codes. I hire a licensed contractor and I rely on the inspectors of the town to ensure that's why you have inspectors, right? You don't rely on the person who's building the house to make sure that it's up to code. That's not my responsibility. It's the builder's responsibility initially, but it's the town inspector's responsibility to ensure that it happens that way, for safety, not for any other reason. And again, I'm not here blaming anyone. I'm not here asking for anything special in return. I'm saying I want to be able to build an addition on my house to take care of two people I care very dearly about, and this has become an enormous issue, none of which is my fault, none of which is my responsibility. I'm not back in front of you because I'm trying to end around anything. I'm back in front of you because someone told me I should come back in front of you. That's why I'm here.
Who told you to come back in front of us?
So the planning board said, I cannot issue you a special permit unless I am sure you already have an ADU. So I had a site inspection. There are things within that construction that do not allow it to be qualified as an ADU, so that's why I'm back here. Now,
And I think that it's going to be very clear to the planning director, if he's the one that you're identifying here is causing your most recent frustration. I think it's going to be very clear to him what this person's opinion is, and I think probably the rest of us as well, although I don't want to speak for you folks, that you have one ADU, you're applying for a second, and the current Carver bylaw says explicitly that this has to go in front of the planning board. Now, here's what I can do. To the extent that there remains any confusion about this, and I spent a considerable period of time tonight going through where this case has gone so far. 2 legal opinions that we have asked for to sort all of this out, although I think we knew after the first meeting what you should be doing. I will be happy to speak to the planning director if there remains any confusion. Because based upon Carver's bylaws, that's where I think you need to go.
so that's great. I'm happy to follow the trail where it goes. It's what I've done for the last 18
And
months.
it's most unfortunate that the trail has been so serpentine for you,
Yeah, correct. I agree with that.
right? I think that you've been given opinions in an effort, opinions from people in town hall, in an effort to try to assist you
I agree
in
with
doing
that
what
also.
you'd like to do. And
Right.
I don't think there's anybody on this board who believes that what you're trying to do is malignant or improper or illegal
Right.
in any respect. It is concerning, obviously, that what was built back in the early 2000s did not measure up to code, for whatever reason. But what was built was an ADU. Ms. Dahl, did you have something you
No,
wanted to say?
well, just like you were saying, Jesse, that just the codes have changed from then to now. So what was met and approved then and what is acceptable
But I
now.
believe Mr. Palmer testified at the last meeting that the codes were in effect since the 1970s.
They're basically, the definition is basically the same.
Yeah.
What's changed is that the ADU state law and bylaw has been liberalized to allow for
I understand.
larger ADUs and to encourage folks to bring in people, either relatives or not, to relieve the housing crisis in
Right.
this state. So,
So to Mr. Poirier's remark earlier, I have thought through significantly about a redesign on this project. I simply wanted to make it clear that this is the pathway that I have chosen. I have not done anything malicious or tried to end around anything. I'm following the rules, and I will continue to. And I have thought about a redesign, and I feel like I was a little bit confused after Mr. Boyle testified. You said that if the apartment is detached and is a certain distance from the main structure, fire suppression would not be required, is that correct? That's correct. Okay.
10 feet.
So it's not to say that I can't work with that. I just don't know how it took 18 months to get here.
here's the easiest way to
Okay.
work with it.
So-
Knock out the kitchen.
Yeah, so I can't knock out the kitchen.
Okay.
It doesn't work. It doesn't work that way. You
And I'm
need-
not sure that the detached suggestion is going to work for you either,
Why is
based
that?
upon the Carver bylaw that was passed in April. Again, it talks about a self-contained housing unit consisting of a complete separate housekeeping unit containing both kitchen and bath, incorporated within a dwelling, all that's you, or existing detached structure.
So I'm saying that if you rule that I have an ADU now, and I can build an ADU that is not connected to my main unit, the only thing that's keeping me from doing this is the cost of the fire suppression system. If I don't have to put a fire suppression system in, I'll build the addition, that's fine. And if I have to qualify it as 3 ADUs, that's what I'll do. Like I'm not I'm not trying to be difficult. I'm trying to say, like, if that's the pathway I need to take, that's the pathway that I'll take. But I wanted it to be known the pathway that I've gone through to get here has been a legitimate and honest attempt to resolve this. I don't want to come before you again, I promise.
And it's regrettable that you have been, I don't want to say led astray, but you've been pulled one way and then another way.
Right?
In the end, the buck stops with us, regardless of what you're told downstairs. Okay?
I understand.
And we work with what we have. We try to help people out when we can within the four corners of the law. And I look at this state law change, and it's pretty clear where you need to be going.
And that's fine. I'll go before the planning board.
And what you asked for initially back in the early 2000s was an ADU.
I did.
And it was constructed as an ADU, even though it may be substandard in some code respects.
Right, so-
It was an ADU, and it remains an ADU.
So that's fine, okay? If that's the way, if that's the direction this has to go, I'm willing to go in that direction. If I can build another ADU that's not connected so that I don't have to incur the cost of a fire suppression system and have a giant tank in my backyard, like then I'll go before the planning board and I'll ask. If that had happened the first time, I wouldn't have come back. Honestly, you wouldn't have seen me again. I would have simply moved forward with it. But that's not the advice that I was given.
Yeah, and again, that's regrettable. And I'm not sure that detaching a second ADU from the primary structure is going to work for you either, based upon the current bylaw. That's something that you're going to have to examine very carefully. But, again, it's very clear based on state law where you need to be going. Once we get over the hump, and I can ask for a vote on this tonight, although I don't think it's really necessary. Once we get over the hump of deciding that what was in there in 2002 was an ADU and it remains an ADU, despite the fact that it's substandard in some code respects, then what you're looking for now is a second one. And second ones have to go to the planning board.
Okay.
This is not extra living space or incidental living space that was characterized the last time. This is, what's in there now is an ADU, full-blown. In my opinion.
So did the new zoning bylaw
Yep.
talk about only one ADU per unit for a house lot?
It says second ADU allowed by special permit.
Right.
From
From the
planning
planning
board.
board.
From the
From the
planning
planning
board.
All
board.
right, so that's up to them then?
Yeah.
Okay.
Yep.
And it's actually state law, not local law.
All right, I understand. And I appreciate your efforts to facilitate that process with the planning board as well, like, so.
You need to see it again?
No.
As frustrating as this has been for you, it's also been frustrating
So-
here.
But I understand
You
completely.
know, you come across very well, you're a good guy, sympathize with the situation. Unfortunately, we're kind of tied in with this,
Yeah.
with the technicality that's here in front of us.
And again, I understand it's been difficult for you. You've spent a lot of time, you've been very thorough. I've never at any point been before this board and felt like you didn't want to help. I'd like to say that as well. So I appreciate that. And if I can get to the planning board and they have the understanding that this is where I need to be and this is why, then I will go through that channel.
And again, I will offer once more as the chair of this board to speak to the planning director and advise him of what our thought process was here. Although he certainly is able to see and hear this for himself on YouTube. But if you were treated abruptly or curtly, I apologize for that. You haven't been here, that's for sure. We've bent over backwards to try to assist in whatever way we could within the four corners of the law. And our instincts the first time in were correct, which is that you needed to go to the planning board. And once more, it's regrettable that you got redirected here based upon a characterization of what you have currently is just extra living space.
I understand.
It's not. That is a self-contained housekeeping unit with kitchen, sanitary facilities, and separate living quarters. Fits
that-
squarely within the definition.
Then that's great. Then that allows me to move to the next step clearly, and that's exactly what I'm looking for. Like, if it can't be resolved here, I will move to the next step as long as it's the right step to take.
But Mr. Palmer is correct in identifying a number of code deficiencies. I won't say violations, but there are issues there that will probably need to be addressed as well. So, you're beyond the statute of limitations to go against your contractor at the time, who should have known better. But if there are deficiencies, and I trust Mr. Palmer's judgment on this implicitly and explicitly, then those will need to be addressed. That's for the current one. Anything you want to say?
No, nothing.
Okay. Mr. Barrington?
I'm satisfied. I hope that we have helped direct it to where it needs to be, and that things will progress for you.
Thank you.
And you get this done.
Thank you. Thank you.
Mr. Poirier?
I hope you only have one more stop.
Thank you.
Ms. Dahl?
Same.
Thank you.
Ms. Mello?
Thank you.
Does everybody agree that this case now needs to be moved over to the planning board for its review? I want to poll the
Yes.
board
Yes.
members individually on this. Mr. Barrington?
Yes.
Mr. Poirier?
Yes.
Yes.
Ms. Dahl?
Yes.
Ms. Mello?
Okay.
It's
Thank
where
you.
we were the first time.
Yeah, I get it. Like I said, I'm not any happier to be here than for you to have me back here. So I think so.
Well, you have a pleasant face
Yeah,
and a nice
sure.
tone,
Thanks.
so we're happy to try to give you some direction. We're only sorry that you have been, as you say, bounced around a little bit.
Okay. All right. Thanks very much. I appreciate
Okay.
your help. All right.
Thank you.
Thank you.
Okay. Now, let me see here. I think that this now brings us to correspondence.
Do we need to close this out at all, or
No, does this case need to?
the case?
That's a
We
good,
didn't have to vote on anything.
we didn't have to vote on anything, that's right. And but it was refiled. So how do you want to do this? You want to,
We'll
Make a
withdraw.
motion to allow him to withdraw without prejudice.
because he indicated that that's what he was going to do, he was going to go
Right,
before the
go
planning
go
board.
before the planning board.
All right, somebody want to make that motion?
Yep.
I'll make that motion
Which is what?
to allow Mr. Bastian to withdraw without prejudice.
Do I hear a second?
Second.
All in favor?
Aye.
Okay. So this case is now off our list, and I expect that the planning board will be seeing it soon. Any correspondence that we need to address? None.
No?
I have something. It's not correspondence per se, but it's important for the board.
Bring that microphone close to you.
The town adopted a new set of online codes and bylaws, and they're searchable online. In the past, we've always had paper copies of the bylaws. I went down and asked for a copy of the bylaws for the board. Actually, I asked for a copy of the bylaws for each of us, and was told that the company that maintains our bylaws now, they're $600 per copy,
If you want
if you want a paper copy.
a book.
Yep. So I was given, there wasn't a copy for us, although why, I don't know. But I was, the permitting department did give me this copy and said we could have it for the board. I truly believe that each member deserves their own copy.
Yes.
This is available for the board. What is online is searchable, and the idea is that while we're having a meeting, if we have a question about what's a dwelling unit, what is, and all the code numbers are changing. So we're used to 2261.
Oh, they
They're all
are.
going into hundreds, 290, all of which will be coming on board as soon, I'm assuming that this has been approved by, the state, because it becomes part of the process.
Right.
So, I think as a board, we should approach the administration and ask for books. That would be my take on it. We do have the one book.
Right.
I don't know how we want to handle the one book, but,
Going to have a bodyguard for it.
well, my suggestion was that the book come upstairs when we have a meeting.
Yeah.
Right.
That it's
Along
it's
with,
left with
along
the
with our
packet.
paperwork,
That
yeah.
was my suggestion, but I was told, take the book.
Oh, no.
So I haven't slept. No.
Because you have the
I
book.
have the
Well, but your thought would be for it to go where if,
Stay,
Afterwards.
stay
It
here
goes
in the
with the
building.
files, that
Yeah.
it stays
Oh,
here
I
in the
see.
building, and that it comes
Got
up.
it.
The problem is, it's very difficult when you're in the midst of a meeting, at least for me, to be looking, and
On
that's what
that.
I was
Right.
doing
Yeah.
tonight. I was looking on my phone, I think it's distracting, it's just my own take,
Right.
well, I
so-
agree with you because anybody's looking at this is probably saying to themselves,
That
what the
she's
heck are
not
they
paying
doing looking on
attention
their
or
phone?
whatever. Right.
And what I was doing tonight was I was reading what came back from the
The new-
AG, trying
the new,
to,
yeah.
yeah. So, the other thought I had was if our administrator, and I know it's difficult for her to come to the meetings, but could pull up, if she was sitting here with a laptop, and could pull up, hey, we need to know what the code says about this, because it is a searchable code. You put
Right.
an accessory dwelling, or ADU.
Yeah, or
And a bunch of
triple deckers
information.
or whatever, and it'll take you right to the section
Yep.
on, yeah.
So I suggest you go out, it's under the town clerk's website, portion of the website. Kind of look at what's out there, but also make a decision about how you want to handle this going forward. Because I don't think we have it in our budget.
What budget is that?
To get books for everyone.
That's 3 Gs.
Right.
There you go. That's my concern.
So what is your suggestion, Vice Chair?
I suggest that we go to the town administrator and ask for a copy for each member of the board. And then when the codes change annually, there is a new way to go out and just print the new code, which would then have to be, the old code taken out, the new
The new
code put in.
code put
So
in.
this is the old code book here?
No, this is up through last year. So the new codes that have come
You
through,
mean the new bylaws?
the new bylaws.
Yes.
That have come through are not
I'm
in
not
here.
in there
Right.
yet.
This is last year's book. But we don't even have last year's book. We're going off,
So maybe we should, I think you're suggesting maybe we wait until the new codes are available to be printed and then we ask for the book?
yeah, well, they should be.
And then we asked, yeah.
Yeah, they should be very shortly available because everything's been approved,
Mostly everything.
mostly everything.
A couple of words here and there were
So
stricken.
chapter,
Okay.
I believe zoning starts with chapter 290.
Yep. The number references, folks, are all different.
All different.
All different.
Right. So I'm wondering if people would then, because of the cost, I mean, maybe if someone at some point is not with the board anymore, maybe they turn the book back rather than
Right,
saying,
right.
Absolutely.
Why
They just
can't
cut-
somebody just make a copy of this? Ms.
why
Mello?
don't you slide it right over to the chair? You can do that in his free time.
Lots of free time I have.
I mean, I don't think any of us need the fancy cover.
Right.
But again, my printer at home is not going to print
All that.
all of that.
What
We're
about
operating
the town
Double
clerk's
sided.
office?
We're operating out of a 3-ring binder. So, I don't need a leather
I
golden
agree.
embossed.
I asked for copies, and this is what I was told.
Okay.
There's over $600.
What about the town clerk's office? Can they not just pull the pages and make copies? Ms. Mello?
That's where,
What does that mean? What are you saying or
that
not
means
saying?
that's what I asked for, and
Would they-
this is what I
Do you
got.
think that they would reimburse us if we offered to get, say, one book and then a Brave Soul trip to Staples and have our copies?
Would you like to ask the town administrator if that's a
Yeah,
possibility?
I think that's fine,
Or at least-
but I would rather wait until we get,
Till we get the,
The
new-
most
once we get
up-to-date.
the new,
The most up-to-date,
up-to-date
bylaw,
one.
yeah.
Yep,
And then maybe just take it there and see what they would charge us to recreate.
hold on to that, Ms. Mello.
She's like, no. No.
I will communicate with the town administrator
thank you.
in due course,
Okay,
because the AG's office has just recently weighed in,
yes.
as
Okay.
all of you know.
Yep.
So,
It'll be coming shortly. What is it, a 90-day waiting period or something?
well, the Attorney General's already approved it, minus a couple of words.
Right, so that's just the adjustment now.
Yep. And then we're having another, right, special town meeting
I just saw that,
in
yes.
September.
And I think that's about maybe a special zoning district for
Yeah.
towns and communities that are adjacent or contiguous to mass transport,
Yep,
right? The MTA, the train.
Okay.
We have to have
We
a
are.
special
We are.
zoning district that would allow for, I think,
Easy access to the team.
not just easy access, but I think for multifamily housing and so forth. Not that familiar with it,
Okay.
but I know that the Supreme Judicial Court has weighed in on this and has said that towns and communities must comply with the law, state law,
Yeah.
like we were talking about ad nauseum tonight.
yeah, I think it's
So,
265 units.
Oh, gosh.
We have, if I'm correct, we have to find zoning for 265 units where the density allowed is 15 units per acre.
well, you know more than I do about this, Ms. Miller.
I went to a meeting last night.
Don't we love her?
We do.
I'm going to retirement.
Do you have anything further you would like to add about this?
That was it.
Okay. Ms. Dahl, you got anything?
I do not.
Not me.
Mr. Barrington,
Nothing to add.
Nope.
do I hear a motion to adjourn?
I'll make a motion to adjourn.
Second.
All in favor?
Aye.
Aye.
Good night, Carver.